Good morning, Mr. Clayton.
As I perhaps indicated, I'm afraid I think it's going to be more satisfactory if I'm sitting.
Absolutely. Do everything to make yourself comfortable, and if you need a break at any stage, please just say so. No difficulty at all.
Thank you, because you may have anticipated something I was about to say. What we've done is prepared a speaking note, which I hope will make the process easier for you.
Certainly.
Can I just invite those around me to hand it out?
Thank you. Mr. Beggs, have you seen this? No.
No.
And perhaps it could be sent electronically as well?
Yes, I'll arrange for that now.
Thank you.
So much. Thank you. Thank you. Forgive me. Unfortunately, I have a very long way down because I'm wearing a very high boot. Gives a new dimension to life. I obviously appear with my learned friend, Mr. David Hughes. The respondents are represented by John Beggs, King's Counsel, and Mark Ray Morgan.
Yes.
Before turning into housekeeping issues, I'd like to express my appreciation for the court's accommodating my current circumstances. And as my lady anticipated, it may be that I will react from time to time. I should also apologise because I haven't conducted many hearings as an advocate at any rate, working electronically. I may get and put my apologies in early for the potential problems which may arise.
Yes.
I just wanted to confirm that the court has received both our note on CPR 15.2
Yes.
and also the respondent's response.
Yes.
And just a correction, but there was a citation of Dallison and Caffery, and I put in the more exact reference, which gives a relevant paragraph number.
Right.
I want to make very brief oral submissions.
Well, do you need to? I mean, I think we're quite keen to get into the meat. No, but just what is there any material difference, or is there any particular new material in the transcripts that is not in the agreed notes of evidence?
Probably not.
No. Well, so why does any of this matter?
Well.
No. If there is something in the transcripts that is material, then we will consider the point. I think we all agree that the court should read the documents as necessary, de bene esse, and that's what we propose to do. But if you're making an issue of it, we do need to know why it's relevant. Well,
the points that we made are in the written note. I'm perfectly happy to move on. We said what we have to say. And ultimately, it's a matter of the court.
Well, let's see if anybody refers to the transcripts as opposed to the agreed notes of evidence.
Thank you.
Bill?
Yeah. I hope it would assist if I could summarise our case.
Yes.
As I indicate at the top of page 1, it's common ground that the appellant suffered an intentional tort of battery by the respondent's use of the taser, and the burden of justifying the lawfulness of the taser lay on the respondent, as the judge expressly found, and for your note I put reference.
Yes.
And then I want to looking briefly, the first, at what directions the learned judge made as to the use of the taser.
So is paragraph 52 still common ground?
52.
This is the legal framework.
Well, I'm not. It seems to be the case that I thought it was common ground. It suggested it isn't, but it doesn't matter very much. That's suggested in the most recent offering from the respondent. It doesn't matter very much because that was what the judge expressly decided. And I just want to go to it, which I think is in the core bundle.
Well, while you're doing that, Mr. Beggs, is paragraph 52 accepted? Still accepted on behalf of your client?
My lady, it is, and it always has been.
Right, okay, thank you.
So sorry.
Don't worry.
Page 39, Mr. Clayton.
I may have to scroll through. Thank you so much. think I wanted to look at, sorry, paragraph 70 actually.
Yes.
Yes,
70, yeah.
it begins at page 42 of the...
Yeah, paragraph 70 to 72 of the judgment.
Yeah,
Yep.
and I just wanted to remind you of certain things that the learned judge decided that, well, she describes the nature of a taser, which come back to, the risk of injury from an uncontrolled fall, and she draws attention to the fact that there are potentially lethal weapons and refers to the earlier case, court appeal case of McCarthy, and that at the first trial, Police Constable Pringle agreed the claimant could have been killed by the use of the taser. Paragraph 71 says it shouldn't essentially be, it should be proportionate, it shouldn't be simply used to get compliance. And then, importantly in our submission, the duration of the initial discharge and any subsequent discharge must be proportionate, lawful, accountable, and absolutely necessary. And I may occasionally refer to that as planned, just because it's easier. And what I really wanted to say about that is that if it wasn't agreed, it certainly was what the judge held, and with respect, it's entirely correct rendition of what the effective legal guidance is, which essentially, as is well known, that guidance must be followed unless there's a good reason not to, and I put forward a plethora of cases which indicate that. And I should also point out, this is at 4.2, page 1 of the speaking note, that at trial during cross-examination, Police Constable Pringle agreed his training was consistent with the application of the guidance, so he certainly knew about it. And also, just to cut through a non-issue, at no stage has the respondent submitted that the police have good reason to depart from the guidance, so the question is that the guidance applies, subject to other arguments which I'll turn to in due course.
And what does the guidance add to the common law test?
So, well, significantly, I will take you through the guidance. But the guidance essentially provides a specific provisions as to the use of tasers. It is comprehensive in its nature, requires a whole range of different things, which I'll touch on in a moment when I was going to develop the case. If you bear with me, I'll deal with that in about 3 minutes.
All right, but just for present purposes, if there's a debate about whether this is just a paragraph, what the section referred to in paragraph 72 of the judgment, it said it is all about duration, not actual discharge.
Yeah.
But for discharge to be proportionate and necessary, does that not simply reflect the common law? It's a potentially lethal weapon, and it shouldn't be discharged unless absolutely necessary and it's proportionate to do so.
Well, there's several answers to that.
Right.
It doesn't reflect the common law.
It goes beyond it, does it?
It does, significantly.
Right.
And what's more, proportionate is not part of the common law. I'll deal with that in due course. It seems to arise from a first instance Northern Irish case, which I'll invite you to.
So what is the common law test?
I'm not clear, frankly, what is meant by the common law test. What this case is about is the reliance, and I'll take you to the defence in a moment, on Section 3 of the Criminal Law Act, which is reasonable in all the circumstances, and Section 117 of PACE, which is again reasonable in all the circumstances. No reference there to proportionality. Indeed, it would be a complete misdirection. The court judge decided proportionality came into play. That would be the submission, and I'll make that in short order. And I also would submit that the Northern Irish Authority doesn't give any reason for the conclusion it expresses. It doesn't bind this court in any event is wrong.
Right, well, you will have to help me on why proportionality isn't a factor in the broad sense when looking at reasonableness.
Yeah, well, yes, I'll take you through that if I may. But
okay.
Well, what I've set out at paragraph at the top of page 2, the second paragraph that's there, is that the judge, with respect, correctly directed herself to the law that failed to apply the test as we develop it. And I then set down summarize the respondent's case, which is no force can be used unless it is necessary. Again, that's not part of the statutory language. He says lawful and accountable. Accountable is one of the words used in the guidance. I'm going to come back to that because that's actually quite important, because these are dangerous weapons, and accountability is one of the factors that the guidance is designed to secure. And he essentially concludes, or the respondent essentially concludes, that it's really a no difference situation, that had they applied the test as he contends it should be applied, the result would be the same with respect. That submission we submit is wrong. And that we say really for the following, I'm going to summarize it very quickly and then take you to the full submission. As I indicated, 6.1, the respondent solely relies on section 3 and section 117, which the judge expressly referred to. And those are statutory powers. That's important. I'm afraid I don't follow this reference to common law at all. I mean, this is a battery, and the respondents rely, as they're perfectly entitled to do, on statutory powers which they have. And as I point out in 6.1, that the statutory powers are simply reasonable in all the circumstances. They don't impose any obligation of proportionality. I'm going to submit that the failure to comply with public law principles renders its acts unlawful. I'm going to look at lumber in a bit of detail, which the court may well be very familiar with, because that's not only the case that introduces the idea that failure to comply with public law principles renders is tortious, which is actually expressly what lumber decides, but it's a kind of shift, and I think, if I may say so, this may not be fully appreciated by those who practice in the field of tortious cases involving police. That appears to be the position. But I then make 3 public policies must follow its guidance, and that's good reason not to. They therefore, in our submission, have to apply a plan. The failure of the judge to apply that test is, in our submission, an error of law. And then I make a couple of points really about the facts, that the video footage puts the court in an unusually good position to determine whether the judge's conclusion was justified. And I refer to Lady Justice Hallis, as she then was in McCarthy, and my Lord Justice William Davis, when granting permission. The court has had the opportunity to view the footage, and my learned junior, Mr. Hughes, will take the court through the key parts of the footage and make brief permission. So for all those reasons, we say this appeal should be allowed. Now, to develop the submissions a little bit more length.
Well, before we get there, perhaps just to again housekeep. As you would expect, all 3 of us have watched the footage on several occasions, each of us. So we've looked at it very carefully. At the moment, our view is that if there are particular passages that anybody would like us to watch again, we'll do that in our own time. We don't need it to be viewed here. We've got the facilities, and submissions can be made if there's disagreement with that approach. A factor then to take into account is that we would have to stop the live streaming, because the broadcasting order does not allow us to live stream anything other than judgments, exchanges between the court and counsel, and submissions. I mean, that can be done if necessary, but at the moment the main point is we are very familiar with the footage, which we've watched carefully. We don't see the need to rerun it in court. If there are passages that you want to particularly emphasise, by all means identify them, and we can watch it in private in our chambers.
First of all, may I say I entirely understand why that approach. What I would like to do is one which I'm afraid I failed to anticipate. So we were going to look at the little short passages of video, but perhaps what could be done is Mr. Hughes, who's going to be charged with this, has some factual submissions, which he could perhaps...
A reference to the section, and we can then go through it by ourselves. Yes, I think that's probably very helpful. Yeah.
Thank you so much. I wanted to begin in terms of what the respondent's case at trial was by looking at the defence, which...
Page 82.
Yeah, and I want to go to page 82. Oh, sorry, where have I So sorry, I want to look at page 85.
Yep.
I'm going to just go here to page 85. If we can, it's really paragraph 17 onwards that I want to look at. But I don't want to spend a lot of time on it. I simply want to emphasize what the language of the defense actually is. Paragraph 17 says, the PC Pringle reasonably believed. That's what the language he reasonable and believe, but there's no reference to proportionality. So there's no reference in the defense to proportionality. So if he therefore has to demonstrate that reasonableness embraces in proportionality, which I'm going to suggest is a somewhat extravagant proposition.
So something can be disproportionate but reasonable, can it?
Yeah. Well, that's pretty standard. I mean, that's one of the reasons why, for example, if the case had been put by the claimant, the learned pleader, by saying this was a breach of Article 8, the right of respect for physical integrity, which of course Article 8 is a qualified right, then the issue of proportionality would be squarely raised for the defendant to discharge.
Yes.
But that isn't the way the case was put. It's been put in a fairly straightforward manner. Battery, statutory powers in response, reasonable belief is the usual defense that's made. And if I can just take you over the page to paragraph 22, you'll see again reference to honestly and reasonably believed. So that's the case as pleaded, and that's of course the case which the claimant's appellants had to meet at trial. If I could next turn to the authorities bundle, I want to just briefly look at the two statutory powers which are relevant. My computer's already messing me about.
Is it the Criminal Law Act?
Yes.
Right. So that's the first page.
That's document 1, I think, in that bundle. And what we see there is use of force in making arrest, for what it's worth, reasonable in all the circumstances, and that is the sole legal test, and it's relevant in this case in effecting or assisting the lawful arrest of an offender. That's, I think, how it comes in. And then, if we look at the section 117, section 117 allows an officer, take it in stages, where any provision of this act confers a power on the constable. And here the power we're concerned with is the power to arrest without a warrant, which is in section 24 of the case. And when exercising the power to arrest without a warrant, the officer may use reasonable force if necessary in the exercise of the power. So, subject to the submission advanced by the respondents, in our submission, the case is pretty straightforward, and it's always been about reasonableness until we get to the question of the policy. And the submission we make is that as a matter of this is paragraph 10, as a matter of straightforward statutory construction, neither section 3 nor 17 oblige the officer to act reasonably, but they do not impose the more onerous obligation to act proportionately. It's important to appreciate, which is one of the implications of the Human Rights Act, that proportionality is a stricter test. And indeed, as I will come to in a moment, it's a misdirection were a court to hold that the use of force under section 3 or section 117 required force to be proportionate. That, with respect, would be a misdirection. Now, paragraph 11, top of page 3, makes the point that I said it was perfectly obvious, so perfectly possible for the pleader to put proportionality in play, but as it happens, he didn't do that. Because it's, again, a standard human rights kind of complaint, breach of the obligation to maintain integrity, physical integrity. So, but that wasn't the way the case was. Now, as far as I can see, the judge applied a Northern Irish case. If we go, first of all, to the judge, that's going to be at page 38 of the core bundle. Can I just double check?
Yep, that's paragraph 44 of the judgment.
Yeah, thank you. And she applies the case of Cameron, which I want to look at, sorry. Yeah, she applies the case of Cameron, so I want to briefly turn to that, which I'm only going to look at the relevant part of Cameron, which is in the authorities bundle at page 60.
And just for my note, so you're submitting Cameron's wrongly decided?
Yeah.
Yeah, thank you.
Sorry, for some reason.
It's all right, it's page 60 of the authorities bundle, paragraph 27 of Cameron.
Yes, I'm sorry. Thank you. I'm afraid my computer is sort of not firing on all cylinders. For some reason. I'll get there in a minute, I hope. Sorry, let me get back into the authorities bundle. Cameron.
Oh, while you're looking for it, we'll remind ourselves of paragraph 27.
Yeah. Thank you. Paragraph 27 contains, I think it's really a summary of the case as the judge found.
Yes, and it's subparagraph
C,
D.
D, yes, so sorry.
All right. No, sorry, C, you're quite right. Yep.
Yes, I was right. So it says drawing together the themes, says the judge at the top. The test applied to both PACE and the CLA is identical, we agree with that. And it is whether the force is reasonable, in other words, necessary and proportionate. Now, so far as I'm able to determine, I've never come across an assertion other than this Cameron case which says anything like it. It's slightly, rather counterintuitive, but this quick submission we make, which is at paragraph 12, is that with respect to the learned judge, there's no reasoning to explain why reasonableness connotes proportionality, no reasoning at all. And it's not intuitively self-evident, if I can put it like that. With respect, it's incorrect as a matter of statutory construction, because if you look at section 3 or section 117, they don't involve any requirement of proportionality. It's also, in any event, and the first instance decision of Northern Ireland, which of course is not binding on the courts of England and Wales.
And what was said about this authority before the judge? What submissions were made about it? Was it said that that was the wrong test?
I don't believe it was.
Was the authority relied on?
Well, it wasn't relied on for that purpose. It was relied on before the judge for an entirely different reason.
Right.
That's my understanding. There was another passage, because when I read the closing submissions made by the defendant, they refer to Cameron in a completely different context. The context in which they refer to it, this is from memory, is that there was a lack of common sense the way the appellant was putting his case, and on that basis they made reference to Cameron. So the proposition wasn't advanced before the learned judge. It's a short answer.
You just asserted that it's not in the statute. You're quite right, it says reasonable. Can you just explain why you say reasonable doesn't include proportionality?
Well, because it's a higher test. So it's okay, we need a question of the lesser, including the greater.
Is there any authority which says that reasonableness does not include considerations of proportionality?
Well, with respect, my lady, our submission is that as a matter of construction, you have to look at the word reasonable, and there's no authority so far as I'm aware, and indeed this is consistent with the position that's put before the court. The only case that points to a suggestion that reasonableness embraces proportionality is the Cameron case.
Well, that was a case relied upon by the respondent. If you look at the written submissions below page 117 of the supplementary bundle, where the submission is that the principles were accurately stated in paragraph 27.
My lady, I
including
entirely
at C.
accept that, but the point I was making was with respect to a slightly different one, which was before the learned judge, that proposition was not advanced.
What proposition?
That reasonableness includes proportionality.
Well, it was, because that paragraph was relied upon as correctly identifying the relevant legal principles by the respondent, at least.
With respect, it was a narrow point. I think we'll have to look at.
All right, it may not matter, but just give
Let me
me.
give me a moment to try. This may take a moment, but we're going to have to look at the closing submissions made by the respondent. It's. I'll find it.
It's asserted by the defendant that Mr. Justice is 77 on page 117.
Thank you, sorry.
But you're right, it's not in the closing.
With the defendant. Where's the authority for that?
Right, you say it's wrong?
Was once of more interest to men. It has particular proportionality in relation to case 77 is that the submission that it accurately summarizes the law is that absent any authority to that effect cannot stand. It's not, with respect to my submission, a question of simple of assertion that reasonableness must include proportionality, because actually one of the justifications for the Human Rights Act, at least in terms of its public law implications, was that proportionality made a difference. That it introduced a structured test which had to be applied. Particularly now people refer to Banknolat and the judgment of the analysis of Lord Sumption. But I don't accept that they're equivalent. And with respect, the submission goes, I think, slightly further than that. If that submission is to be made, one would expect some, either say it's declared from as a matter of statutory construction, to which the answer is no, it's not, or you would expect a line of authority which says it's reasonableness means that of course what we say is a reference into a statute, and that's the authority that matters. That's why, because it's if I've laboured it. What I want to do, if I may, is spend a little bit.
You need lumber? Yes.
Sorry, just before. Criminal judges have used disproportionate. Well, why is
accountable and absolute?
Maybe we're at cross purposes.
It may just be that if one looks at plans, so to speak.
For example,
It's proportional. It's better than proportionality, and that I was going to computer keys. I was going to look at paragraph 26. Yes, which my lady has. And that develops and numerous other opposition which reach can render.
You very kindly took us to the pleadings of Justify. And you.
Well, I'm not sure that it needs that together. Well, there is, because I'll come to it in a minute. I haven't yet taken you through it.
right, paragraph 26, paragraph.
Then I wanted to take you through. Just give me a second. I want us to go to 35 and 36. I want us to make a point about that it's a way to pass something that was narrative of a section of a statutory provision at an early stage. to 68. Lawful authority, narrow sense, although authorised, is that we submit that the failure to comply with specific to that, because, and in this context, leaving aside anything else, it's important, as my court will recognise, to appreciate that the taser is a firearm for present purposes. So it's obviously inherently a dangerous piece of kit. Now I want to go through, if I may, the guidance, because the guidance in final analysis is both comprehensive and prescriptive in goals. So if I could take you to that, it begins in the authorities bundle.
I think the supplementary bundle, page
No, it
53.
begins in the authorities bundle, and then it moves to the supplementary bundle. So I think you'll pick it up at these. Okay. So I mean, told how to use a computer sensibly, which is not done so far. Okay, it's item 15. If you could turn to that, please. It's you have is where the guidance emanation the we set 4, and you'll see in the middle, the third line down there, after the legal framework, which we'll touch on briefly, the use of force, firearms, and less lethal weapons. It's unfortunately it's slightly difficult to get out because basically you have to click and you get to one document to another. If you get to the bottom of the next page, you'll see this everywhere. It says important document for the police to give consideration to. If you go to page 406, you get the legal framework, and then turning to page 407, a section is fourth down, conducting energy devices, taser. Yeah, conducting energy devices. In often time-critical decisions, police individuals are still accountable through the law for their actions. There's then a discussion of human rights, but it then turning to 408, all officers have an individual responsibility for ensuring they're aware of relevant legislation, informed about the extent of their legal powers and the context within which the powers can be properly exercised. The context in that circumstance includes, of course, guidance. And they say a bit more about that in the paragraph just above the European Convention of Human Rights.
We're now going to page 53 of the supplementary bundle.
That is correct.
Right.
I was confused.
Which, speaking for myself, I've read. Have you
Yep.
read? Guidance. Yes.
Yep.
Yeah, I think we've. What would you like to highlight?
Well, can I just get to 53 and then I'll do just that. I'm sorry, I'm trying to get through this at speed. I want to I think we start. Well, it starts with what a taser is able to do. That's the second paragraph, 53, and one of the number of tactics available. It describes at 54 what a taser is. We're here concerned, I think, with the X26.
Yes.
And it explains how they're activated, and that this may be important to take up now. As I understand, if you look after the two paragraphs that follow from Taser 7, as I understand it, that when the taser is used, it will always last for 5 seconds. So, and I make that that point because the suggestion that plan only applies to the duration of the use of a taser doesn't really make much sense, because I'm going to come back to how you should analyze or construe policies in a minute. But clearly, if it's always at least five seconds, then, which as I understand it, that's what those two paragraphs effectively are saying, then it would fall within the scope of the plan principle. That's my point. I'll come back to that, but I wanted to show you that passage there because it may be important in terms of the construction of the breadth or otherwise of the plan principle. It's just that what I'm going to submit in due course, so the word duration is not actually terribly helpful when you look at that in the context of what a plan is supposed to cover. And then turning on to a slightly different point, just above operating requirements, it's classified as work-related equipment like firearms, not as personal safety equipment. So it's at the top end of the scale. If you could next turn to 56, which describes the various effects. Which obviously it's probably the most obvious effect is an uncontrolled fall, which is why it's listed first. But the point I want to make about the effects is when a taser is used, it's not entirely predictable what the outcome will be in terms of the injury that may be sustained. And in our submission, that means that one has to be cautious about its use, precisely because you cannot accurately predict what particular adverse consequence might arise out of its use. I hope that's clear. Next. If you could turn, please, to 60. Under deployment, this is a point made by the respondent, is that it's not practical or possible to provide a definitive list of circumstances where a taser would be appropriate. Well, that may be so, but I'm not sure it takes us very far. Then we come to the following page, which is page 61. The taser should only be used as a proportionate response to an identified threat. And it's important to see an identified threat because you'll have a view from seeing the video, but in our submission it's far from clear that there was any threat posed. There was failure to cooperate. That's not the same thing. And then it shouldn't be used to secure compliance. And as the chief rightly observed, the language of plan begins by the duration of the initial discharge. That's the word used. But since the only reference to the duration is 5 seconds, we would say, in effect, it means the use of the use of the use of a taser for an initial discharge must be proportionate, lawful, and accountable. And I'll make some submissions about that in due course. If you could go to page 62, risk factors. There are a number of different ones. Again, head injuries from uncontrolled falls is the primary one, certainly the first primus inter pares. It should be recognised the list is not exhaustive, other risks may be apparent, and then indicates that the risk factors have been identified by operational experience, medical evaluation, and the manufacturer's guidance, which is another reason why the guidance from the College of Policing is important, because they're drawing on quite a lot of specific information which only they have access to. If you could next go, please, to page 65. The medical assessment. There is a requirement when a taser is used that all arrested persons who have been subject to the taser must be examined by a specially trained healthcare professional. That obviously reflects the gravity of the injury that may be sustained by virtue of a taser, and that applies across the board. Likewise, and this is relevant to accountability, which I referred to earlier, if you go to 67, you'll see that the use of force reporting, you pick that up just over the page 68, that there is an obligation to report the use of a taser.
And we've got the form here.
Sure.
Yep.
But the point I'm making is that that's one of the instances in which the accountability element of the plan is actually secured, is that there's a form fully exercised. And indeed, if you go further down the page, there's an evaluation checklist which has to be performed, and also photographs. Well, the cartridge has to be checked, and photographs and videos have to be retained. And also in this collection of ways of seeing how things should be treated, how tasers should be treated, it then again refers to the medical examination which is supposed to apply. And if you could then next turn to page 70, you'll see that there's an important part of the guidance is the monitoring and oversight of taser use. And you can see it's monitored by a number of quite significant bodies. And finally, I say finally, I mean, that may sorry, I got to training, which I just managed to hit. Sorry. Training is...
So minimum contact time for initial training, 18 hours. Minimum 6 hours a year for refresher. Need an appreciation of physical and psychological effects of these devices.
Yes. Thank you. I'm sorry, I've knocked by a machine. So.
Don't worry, page 72. So we've read training, I think.
Yeah.
Maintenance, I don't think it helps particularly.
No, it doesn't.
No.
Can I just want to see I've covered all the passages I wanted to. I'm sorry.
You've certainly gone through all the things in your speaking note.
Oh, in which case, thank you. That's helpful. Thank you for that. In which case, can I just turn to what we want to say about it? Really, it's paragraph 14. It is to make the following steps about the guidance, which is that obviously a taser is a firearm and therefore by its nature dangerous. And as we submit, it's important to appreciate that the guidance is specifically tailored to accommodate its fact that this is a specific and dangerous device. The guidance extensively explains its effects and risk factors. I make the point I made earlier that the fact that no permanent injuries result has no answer to its use, since its impact is inherently unpredictable and may have serious adverse consequences. The guidance requires substantial training of taser users. It specifically stresses the decision by an officer remains a decision for which the individual should be accountable. It does say that. I'm not sure whether I took you to the passage, but that is accurate. As soon as it is practicable, someone tailored arrives at relatives, they must be examined, and the danger of it is acknowledged by the transparency obligations of mandatory reporting, photo and video obligations, and monitoring obligations under the guidance. In fact, what I want to submit, so I seem to have, give me a moment. Actually, I can't seem to immediately find the submission. Can I actually go back to page 1 of the speaking note about the submission as to how we say plan operates and how it should be understood? If you pick it up at really at the top of page 2, is each of the words of plan in our submission is significant.
Yep.
And must be construed both singularly and, importantly, cumulatively. Cumulatively, in our submission, it imposes a specific and strict regime to regulate the use of tasers because of their inherently dangerous character. And we also emphasize that the code is both prescriptive in terms of the obligations it imposes and comprehensive. And in our submission, subject to the point about what the scope of plan, which I'll come back to, in our submission it imposes important and different obligations than proportionality used in the sense of my Lord Justice William Davis used when he was talking about it, forgive me, in the context of reasonableness having to be proportionate. What in essence we're saying is that there's a special and strict regime for tasers because that is a device which imposes special and particularly significant dangers. That's why it's there. The respondents contend that this particular incident does not come within the scope of plan, the phrase that I'm using, because plan is confined to the duration of the initial discharge. Well, it's difficult to know what's meant by the duration of the initial discharge, because we're told in the guidance that it's always 5 seconds. So since it's always 5 seconds, it must inevitably apply in our submission. And so leaving that to one side, and I suppose I've set that out really at paragraph 20 on page 5 of the speaking note. We then rely on a couple of principles, or a few principles, which emanate from Lord Reid's discussion in the Scottish Supreme Court case about the meaning of policy, this is paragraph 21. I've brought sent the authority to the court. I don't think it's necessary to go through it. The relevant paragraphs are 18 and 19 of judgment of Lord Reid. That's the first thing to say. But essentially, Lord Reid makes a number of points that the interpretation of policy is a question of law, and in our submission, that's important to appreciate. It's not a question of when's winner's application. The policy has to be interpreted objectively in accordance with the language used, read in its proper context, which includes the subject matter and the objectives sought to be achieved. Now, in our submission, that is an important factor when you come to interpret the scope of the guidance as a whole and specifically a plan, one can see that the subject matter is the specific use of a specifically dangerous device. You can see what the objectives which are sought to be achieved, because they basically involve rigor about its use, training, transparency, and various other matters of specific detail. Lord Reid also says that policy statements should not be construed as if they were statutory or contractual. So that what that, with respect, entails is that the courts will, in giving effect to the purpose of guidance and understanding what its effect should be, would approach it with a degree of latitude which you wouldn't use if you were looking at statutory or contractual words. So it's just a different and broader exercise. And in our submission, taking it broadly, the plan must apply to the duration, to the initial 5-second shot at the appellant. Can I next, I've dealt with, I think, there's no suggestion here there was good reason not to apply guidance, so that's not an area we need to look at. I just want to turn to the difficulties about disclosure, because you can see, I wonder if we could go to the skeleton actually, our skeleton.
Speaking entirely for myself, obviously we've read the history of the disclosure exercise and your careful submissions on the point, but is that really going to help us today? I mean, the short point is the guidance was before the learned judge below.
Eventually.
Yes.
Yes. Well, subject to, well, I understand the pragmatism of the point that my lady makes, but I would make 2 brief points in response, if I may. The first is that it is very difficult to understand how, as the respondent contended, it took the view that it wasn't relevant because it wasn't adverse to the claimant's case. And I want to deal with another point in that context, because it's made, and with respect, it cannot be right, which is it's said in a sort of vague way, well, junior counsel must have known about the guidance anyways. I mean, disclosure is there as an obligation precisely because one's not supposed to...
These may be very good points, but just please answer my question, which is why does it help us today?
Well, it would help in this sense if my lady or the court were in our favour, saying something about the approach taken, the stance adopted by the respondent's disclosure would be important. And I make that particularly in the context of Lord Dyson's remarks or adoption of Mr. Justice Stanley Burton's point about how there's a constitutional imperative to disclose guidance. So I'm not saying it brings it home for us, but what I am saying is it's an important secondary factor to which the court would give effect or ought to consider if it took the view, if it favoured our submission.
Is there anything you want to add to your skeleton on this?
No, I was simply just reminding you of the position that was taken, particularly in paragraphs 15 to 20. And all I will say is that is very difficult to understand. And my lady will know perfectly well what I mean by that. And they're apparently based on counsel's advice. Is that wrong? It's said. No. All right, I'm told it wasn't based on counsel's advice. Well, I obviously accept that. Well, you can see 15 to 21 what's said. We just repeat the correspondence. Anyway, I'll move on because, as my lady points out, it's not perhaps central to the appeal itself.
So the next section of your submissions is basically plan must apply, and if plan applies, the judge couldn't have reached the conclusion that she did.
Yes, exactly. So.
Right. Just assume or proceed entirely hypothetically for the moment on the premise that the plan factors fall within a consideration of reasonableness. It follows then that you would still say, would you, that the conclusion reached by the judge below was wrong?
Yes.
Is that how you put it?
It is how I put it. And I say that because
so applying plan factors, whether independently as a separate point or because they form part loosely of a reasonableness consideration, the judge was not entitled to reach the conclusion that she did.
Yes, because of the specific nature of what plan entails. That is a more structured test. The point I was making earlier about proportionality versus reasonableness. It's structured, and I hope I've made that good by indicating the structure.
But even without that structure, even if it's just reasonableness and it's all relevant factors, it's all the circumstances, do you still say that that then the judge's conclusion below was wrong?
I do say the conclusion is yes, I do say that.
All three findings?
Yes.
Honest belief, objectively reasonable, and...
Oh, no, sorry, no, no, it's objectively...
So it's questions 2 and 3 that you challenge?
Yes.
The answers to questions 2 and 3 that you challenge?
Yes, precisely so.
Not answer 1? You don't challenge honest belief?
Well, I'm not going to debate it with the court.
Well, I just want to be clear. So,
no, I entirely understand.
So you're going for... You're challenging the finding of objective reasonableness, the two findings?
The two findings. Although, as I say, and I hesitate to say the primary position is that you have to look to the guidance first.
I think we understand that. I just want to see what your fallback is, as it were. Okay.
Yeah. I mean, I suppose it's also worth making this point about fallback, is that because of the because of the nature of this type of litigation, civil actions against the police, issues of reasonableness, see Lord Diplock in Dallison and Caffery, are questions of law. So it's not a question of simply saying, did the judge get it wrong? And have I demonstrated that there's a factual error? It's not a factual error here, it's a question of mixed fact and law. Because of the Dallison and Caffery has said that's been the position in the context of police for the last 200 years. Indeed, Lord Diplock speculates it may have been a device formulated to deal with the Jacobinism of juries, because it goes back to the 18th century. But it's a very long-standing principle, never been suggested to be wrong. So it's reasonableness in a special sense as well, is what I'm saying. We also made, your lordships will have seen, or my lady and your lords will have seen, that we make reference to the review of the independent Office for Police Misconduct. I don't propose to say anything beyond what we have put in writing about that in the skeleton, but I would submit that my lady and my lords might find it of assistance to look at further into that report, because what the report underlines, which is inherent to this appeal, if I may say so, is that the nature of use of tasers peculiarly involves public policy questions because of its serious adverse impact. That's why there's a special procedure which governs it, and that has been a subject which various independent bodies have looked at with concern for some time. I don't think I need to say anything more about that. Can I just have a moment?
I'm trying to get things going. If you can think of a better way of getting into answers 2 and 3, then please help me out. I'll have another go.
All right.
I don't want to overstep the boundaries of
Thank you, my lady, my lords. Can I now hand over to Mr. Hughes to deal with some of the factual points which arise particularly?
Yes, now, before you do that, and so that you hit here, I think, speaking entirely for myself, this is important. And you've identified your position, as it were, on reasonableness on the facts, and you say you're challenging paragraphs 91 to 106. Those are the two sections that deal with the answers to questions 2 and 3. And I think it will be important and helpful to us to, I mean, you see what Mr. Biggs is going to say. These are findings made and reasoned. Interested and would benefit from the assistance of either yourself or Mr. Hughes on the facts as to what is wrong with these findings in a way that enables the court to interfere with the conclusion.
Right. Well, okay.
I mean, if Mr. Hughes is ready to do that then, and that's how you've divided it, that would be very helpful. I'm just, I hope, flagging up what we would find of assistance.
Yes, can I just make an intermediary point, which, as the judge rightly says, first instance judge, the video is obviously a key question.
Yes.
And our submission in that area is that the court can readily form its own view about the position. So, although the judge has made findings of fact, in our submission, those findings of fact seem to have to be seen through the prism of what the court makes of the video itself, and whether, for example, it supports the position that that judge found. Can you just give me one moment?
Yes, thank you.
Well, my lord, can I, my lady, can I ask Mr. Hughes to
Yes.
deal with the factors? What do you want? Oh, I'm sorry.
Very pleased to be hearing from you, Mr. Hughes, as junior advocacy is always encouraged.
Thank you, my lady. What I was proposing to do for my lady and my lords is take the court through what we say are the key passages, some of the key passages at least, of the body-worn camera footage.
And if we need to go offline, we can, but we have got, would it be most helpful to use the breakdown, which I think is in the, is it in the main bundle or the supplementary bundle, page
74, my lady.
74, thank you. Yes.
My lady, having done 2 trials in this case, one of the things one learns is that the exact timings are apt to vary according to
Yeah, to start off, we're an hour out, so it's not 4:45, it's 5:45.
What I was proposing to do, my lady, is to take the court through them with reference to the internal timings.
Yes, okay.
Before I do that, I want to say, make some brief observations about the generality of what can be seen in the video footage. And we submit that it shows the following. It shows that a man who talks with officers for quite some time before he was arrested. Interactions that were, on the whole, amicable. There were discussions, for example, about the appellants working with young offenders
And police in that context. Yep.
That at the time of the final breath test, at the end of the final breath test rather, Mr. Worcester, calling him back because he's retired now, says to the appellant, sounds like that's it, indicating what Worcester perceives to be successful completion of the test. That happens before PC Rickman says that the machine was showing insufficient. When told he is under arrest, the appellant makes the point repeatedly that Mr. Worcester had said to him, that was it. When the appellant makes that point, he is met with the answer that the machine said insufficient, which was right, but did nothing to acknowledge the point that he was making. Trying to watch my lady's pen to make sure I don't go too fast.
Yes, don't go too fast, thank you. I'm making a note.
The appellant did not comply with the arrest, and on a couple of occasions he pulls his arm from the grasp of officers. But repeatedly, between being arrested and being tasered, he is standing very close indeed to police officers. And at no point, for example, does he strike or attempt to strike any of them. Grab or attempt to grab any of them. Shove or attempt to shove any of them. Make any threat to any of them, whether verbally or with gestures. Or give any kind of aggressive stare. In our submission, what the body-worn camera does not show is any objective basis for believing that the appellant was readying himself to attack officers. When he was tasered, he was in the middle of a conversation with his friend, Mr. Cole.
And what about the watch?
The watch had, the learned judge below accepted that the claimant's account of the watch may be right. There is she referenced PC Pringle's perception of it. But that needs to be viewed, we submit, in the context of what happened after it. What happened after it was the claimant standing with his arms folded in front of him, his feet parallel to one another, in what is very emphatically not a fighting gesture, a fighting stance as it was described. The footage also does not show any objective basis for believing that events had reached the stage where an officer was going to have to come forward and place handcuffs on the appellant, and that the appellant posed a significant threat to an officer who did so. The footage shows that the time that passed between the appellant being arrested and being tasered was only 1 minute, 46 seconds.
Just, can I find that on the chronology, please?
Yes, my lady. Yes. It's at page 77, 605 in the timing on the left-hand column.
Thank you. Hold on. Told he's under arrest. So what, you're talking...
1933 in PC
Yep.
Rickman's and 1110 in Mr. Worcester's.
Yep.
And then
Taser is 607.
607, so 2119 in PC Rickman's and 1257 in
So
Mr. Worcester's.
1933 to 2119. Yep, that's how you get to 46. Got
1
it.
minute 46 seconds, yes.
Yep, thank you.
I'll now refer to the specific passages to which we...
And sorry, how long PC Pringle arrives, and he's called in. Either PC Worcester or Rickman have said, I think if he goes over, I'm looking at 0557, PC Worcester on the radio, presumably to Pringle and PCM. He knows what's going to happen. We've given him 3 chances, realised he's had some gum in his mouth. I think if he goes over, he'll kick off. Yeah, maybe not kick off violently, but he's not going to be happy if he gets arrested. Then PC Pringle arrives at 0600. Oh no, they drive past to a nearby street. Then we get the 5th breathalyzer test that doesn't work. And when does... Van pulls up at 6:04. That's when PC Pringle arrives.
Thanks.
So 1907. So PC Pringle is on site a maximum of 1907 to 2119. Yep. Is he the only officer with a taser?
On the video, there's another red dot that we can see after.
There is. I think one of the other officers had a taser, and obviously we can see PC Rickman pointing his powder spray.
Yeah.
At the,
yes, that's a good. My lord makes a good point. Yes. Anyway, what's the evidence? Was there any evidence about this?
There wasn't. That other officer who we think had a taser was not called to give evidence.
But you can see on the video another red dot light up.
Yes.
And it wasn't discharged.
No, it wasn't.
That must be PCM.
We think that was PC Marudka, yes.
Who had the second taser.
Yes.
Thank you.
I'm going to identify short segments of the footage to which we invite my lady and my lord's attention at the court's convenience. The first is the same. I'll start off with PC Rickman's, if I may. And the first is from 1830 to 1845 in his internal findings.
Sorry, I've lost. It's my fault. I didn't hear you. We're looking at PC Rickman.
Yes.
You want us to watch the video?
Well, I was...
Not now, but yes, that's
Yes.
the section you want us to watch on PC Rickman's
Yes.
BWV, right?
1830 to 1845.
Yes, my lord.
Thank you.
And what we say can be shown here is this shows the end of the final breath test. Important observation to this point is this. Up to this point, save for the learned judge's finding about not blowing properly into the device, the appellant had done everything that was asked of him. The single issue of non-compliance that there had been to this point, the judge found the failure to blow into the machine properly, would not, in the context of this case, give any reasonable basis for fearing that, for believing that the appellant was going to attack anyone. At the end of this section of footage, Rickman asks the appellant to put his hands behind his back and he, in preparation to apply a rear stack handcuff on the appellant. The next brief passage I was going to draw.
And so, and what's the point that you make there?
The point there is this, that we have a man who the judge below had done, with that one exception, which doesn't go to any active resistance at all, still less aggression, done everything that was asked of him.
Right.
Despite that, a decision is taken not only to handcuff him, but to handcuff him in a rear stack position. The next passage I was going to invite the court's attention to, I've noted it as 1910 to 1935.
Mm-hmm.
And what we see...
Again, Rickman.
Yeah, still in Rickman. It's Rickman until I say Worcester money. In this one, there's a specific time I've noted, 1920. One can see that Mr. Worcester has hold of the appellant's right arm. The appellant doesn't strike him, doesn't grab him, doesn't shove him off. He carries on talking to P.C. Rickman, trying to make his point. Following on from that, I've noted to invite my lady and my lord's attention to footage from 1935 to 20 minutes. And what we see here is this. We've got, the appellant's got police officers on both sides of him. He turns to his side to try to find someone who will listen to his point. He then turns to face Mr. Cole, his friend, to try to make his point. He does pull his arm away from an officer. But despite these officers being in easy reach if he were minded to turn violent, he does not do so. Another thing that the court will note in this passage is that P.C. Rickman has his parbor spray pointed at the appellant. And one sees that specifically, I've noted, at 1955. And it's pointed at the appellant, notwithstanding the proximity of other officers. We couldn't ask P.C. Rickman about this because he wasn't called as a witness at either trial. And of course, P.C. Rickman didn't use his parbor spray. But the learned judge referred to P.C. Pringle's suggestion of cross-contamination, the idea that when one uses the parbor spray, it can come into contact with people standing around, when considering whether there was an objective basis for using the taser over the parbor spray. P.C. Pringle told her that this cross-contamination happened nearly every time parbor spray was used. That is not a risk that stopped Rickman from drawing his parbor spray. And of course, when the appellant was tasered, no one was as close to him as we see here.
Sorry, when no one as close as P.C. Rickman?
As the other officers are.
Right.
Sorry, the other officers who are standing right around the appellant at that time.
By the time the appellant is tasered, there are 5 officers there, is that right?
Towards the end of the passage I just referred to, the 20 to 2055, we can hear someone shout.
And you'd like us to watch this as well. This is section 4, is it? I've got 1935 to 20 minutes. And this is their next section coming up.
Sorry, this was at the end of the 20 to 2055, my lady.
Got it, thank you.
Just before the end of that section, we can hear someone shout, "You struggle, you get tasered."
Yeah.
The next section I was going to speak about very briefly.
And what's the point about that?
That there is an apparent readiness to use the taser without proper reflection on the gravity of this instrument. That was the point about the second observation I made. Does my lady want me to say anything further about the first one, about Rickman and his parbor spray?
No, that's fine, thank you.
Very well. The next passage I was going to mention was 2055 so it's following straight on from this through to 21:15. We're getting very close to the tasering itself now. At the start of this section, we can see again that Rickman again is pointing his parva spray at the appellant. We can see his hand extended out in front of him. He moves back a little, and at 21:07, PC Pringle crosses in front of him, in front of Rickman, not in front of the appellant, and moves to a position behind the appellant. PC Rickman then moves closer to Mr. Cole, who is standing a few steps in front of the appellant, with whom the appellant is talking. And Pringle stops a few paces away from Mr. Cole. The next section I was going to invite the court's attention to is 21:15 to 21:22. This shows the actual tasering. We ask your lordship, my lady and my lords, to note that Worcester, who we can see in this, at 21:18, just before the tasering, is turning towards Mr. Cole. He's turning to face Mr. Cole, not the appellant. There is no objective basis, we submit, for believing that anything was about to happen other than that the appellant would continue talking to Mr. Cole. No officer started the process of stepping forward to seize the appellant. No officer in the records made afterwards said that they started the process of doing so. And no officer gave any signal that they were about to do so. There was also no split-second decision to make. As the learned judge observed, the appellant was already under arrest for offence of comparable seriousness, in that he'd been arrested on suspicion of failing to provide a sample. There was no pressure of time. Only 1 minute, as I said, only 1 minute and 46 seconds passed between the arrest and the tasering. There is some post-tasering footage that the court may find of assistance. At 21:22 to 22 minutes, I invite the court to look at that, and we say that at 21:37, my lady and my lords will see another man get out of the car. His name is Mr. Grant. Mr. Cole is clearly in some distress at what we see.
So Mr. Grant was in the appellant's car?
Yes,
Yes, yes.
Mr. Cole is the gentleman who got out
Yes,
and been talking.
yep.
At 21:51, Rickman says, because he refused to comply. And at that point, we can see that another officer has Mr. Cole, who has been entirely cooperative, on his knees and being handcuffed in a rear-stacked position. Rickman continues. He says, I tried to arrest him and he struggled. He says not a thing about anyone being about to move forward and seize the appellant. Between 22 minutes and 22...
Hang on, this is not in the chronology. That statement. Unless I've missed it. Yes, okay. So 0608, PC Rickman, is this it? Yes, because we were trying to arrest him, we gave him enough chances.
Yes.
Is that the entry?
Yes, that's the entry. Sorry, my lady, if I'm a bit slow with the speed reading, it's a bit challenging for a dyslexic.
Take your time.
Thank you. It's that exchange.
Yep.
At 22 minutes to 22:40, invite my lady and my lord's attention to the discussion that Rickman has with Mr. Grant. Mr. Grant says, there was no need for that. Rickman responds, we gave him enough chances. Mr. Grant says, he was talking to you. Rickman says, he wasn't talking to us, he was shouting at us, and he resisted arrest. Mr. Grant asks, shouting, you get a taser for shouting? To which Rickman responds, yes, because we were trying to arrest him. Mr. Grant responds, I've been working with police for 15 years and you're going to tell me that. My delivery does not convey the full emotion with which Mr. Grant speaks. But we have not the tasering officer, but an officer who was part of this enterprise, giving a view there. We couldn't ask him about that because he wasn't a witness. Then at between 22:40 and 23:10, we can hear Mr. Grant posing what we submit is an abstract question. He says, was he throwing punches? Was he getting physical?
Is that on the chronology here?
No.
Let me just check that one.
It's not.
No, it's not.
So who said those words?
Mr. Grant.
Mr. Grant.
And I think, to be fair to PC Rickman, he did say at the end it was for resisting arrest and presenting a danger.
Yes.
We understand your points on that.
Yes.
But, I mean, if we're saying what he said, it's better to be accurate.
Yes. I'm going to now move on, if I may, to some brief passages from PC Worcester's body-worn camera footage. First brief passage to which I invite the court's attention is 11:50 to 11:55. At this point, it's again where we see PC Rickman having his parbor spray pointed at the appellant. The appellant is in very, very close proximity to other officers. If he were minded to pose a danger to anyone, he is objectively in a far better position to do so at this point than when he is standing, arms folded in front of him, feet parallel, talking to a friend, out of reach of any officer, as he was when he was in fact tasered. At 12:40 to 13 minutes, particularly at 12:42, this is when we start to see Pringle making his way across the pavement. Rickman moves back to allow him to do so. As he does so, the claimant, the appellant, has his right hand behind his back. His left hand is stroking his chin. His hands aren't in his pockets. No question of him reaching for something or having them out of sight of people. The appellant is having a conversation with Mr. Cole. He moves his right arm from behind his back to around his front.
And at this stage, sorry, he's under arrest.
He is
Been
under
arrested.
arrest.
Yes. Yep.
So he's then got his arms folded in front of him. His feet are parallel with one another. The judge noted that Pringle accepted in both trials that this was not a fighting stance, as PC Pringle had said in his MG11. Rickman is standing a couple of paces to the side of Mr. Cole. If there had been any threat, he was well placed to use his less dangerous pepper spray. We see again from this footage, before he is tased, before the appellant is tasered, Worcester's camera angle moves to turn in the direction of Mr. Cole. So on this footage as well, there is no objective indication that he or any other officer is about to step forward and seize the appellant. And then we see the appellant fall back. He hits his head on the ledge of the doorway, of which Pringle was aware. And that's a blow that the respondent described as glancing. A few closing observations now. PC Pringle accepted in evidence at the first trial that he could have killed the appellant. What the footage shows, what my lady and my lords will see from it, we submit, is a sequence of events that showed no objective basis for believing that that the appellant was about to do something at the point at which he was tasered, or had done anything up to that point which justified the use of potentially lethal force. He pulled away from police officers, he'd not complied. But my lady and my lords will have the list of things that he did not do that I set out at the beginning of my submissions. In those circumstances, the use of the taser on this appellant, in these circumstances, at the time it was used on him, was neither proportionate, legitimate, absolutely necessary, or reasonable. Unless there's anything further with which I can help my lady or my lords, that was what I was proposing to say.
Not at this stage, Mr. Hughes. Thank you very much indeed. Anything further from you, Mr. Clayton?
Nothing. Sorry, I was going to stand up. Nothing further, unless there's any questions which I can assist with.
Not at this stage.
Thank you very much.
Do you want a break? Do you want a break? Are you okay? Yes, Mr. Bates.
My ladies, my lords, it is, the court might think odd that the appeal has been predicated around guidance which became available to my learned friends on the 4th of July 2022, 10 months before the trial, and was never pleaded, nor was a Human Rights Act ever pleaded, nor was disproportionality expressly pleaded in the erudite sense advanced by Mr. Clayton, nor did the guidance appear in my learned friend Mr. Hughes's opening skeleton, which the court will find at Supplementary Bundle 81. I needn't take you to it, but you'll perhaps take it from me. There's no reference to that guidance. Not in the reading list, nor is it even mentioned in closing written submissions, Supplementary Bundle 154 onwards. And where one might have found it, for example, at paragraph 14 onwards, again, there's no mention of the College of Policing guidance. Perhaps even more significantly, PC Pringle, who had retired by the time of the trial, he was cross-examined about bits of the guidance, but oddly enough, not the bit that contains plan. And for the court's note, that is Supplementary Bundle 261 to to 267. I won't take you to it because the court will see the cross-referencing back to the guidance, and that
Is that apparent? Is that notes or transcript?
that's transcript.
Where are the agreed notes of evidence? Are they in here?
I temporarily forget that this is the court transcript, and what one sees from 261 to 267 is that the paragraph beginning the duration, that is the plan paragraph, is conspicuously not cross-examined to, even though the paragraph just above it is. So the entire predication of this appeal was not even put to PC Pringle. If the court would wish me to take you through line by line, I can do so, but you get it by, perhaps I should give you cross-references to the guidance just to make your task easier, if I may. Could I take you to 262, please, or 261, just for completeness? The court can see at letter F for Freddie, my learned friend Mr. Hughes cites from the APP, the Authorised Professional Practice. He dates it, and then at the bottom of 262, between letters F and G, he refers to page 262 of the trial bundle. That is, for this court's note, supplementary bundle, page 56. And as the court can plainly see, that relates not to the PLAN section. Likewise, if the court looks at the top of page 263, Mr. Hughes perfectly properly took PC Pringle to the not able to control their posture. Just for your note on the transcript, that's supplementary bundle 56. If we then turn to 264, please, the court can see between letters A and B that Mr. Hughes took PC Pringle to page 267 of the trial bundle. For this court's note, that is page 61, and starts with some of the paragraphs above the PLAN section, including the paragraph about not using taser simply for compliance. But then he moves on, and the paragraph relied upon by my learned friend Mr. Clayton, King's Counsel, starting the duration, is nowhere mentioned. And so this court might be left with the impression that the sentence starting the duration on supplementary bundle, page 61, was never in fact relied upon below, either in opening, in closing, in cross-examination, in pleading, nowhere, but has now been placed with customary eloquence centre to the appeal. It strikes us that that is very obviously inappropriate and unfair, interesting though it was. But here, if I may say so, is the rub. Notwithstanding the total absence of pleading, reference to the trial judge and so forth, of what is now the centre of their case, Mrs. Justice Hill very carefully dealt with the guidance, and she cited it expressly at paragraphs 70 to 72, including what I'm going to call for short the duration sentence at 72. So that's core bundle 42 and 43. The learned trial judge also, we respectfully invite this court to find, accurately distilled the law that applied to her considerations in paragraph 52 of her judgment at the bottom of core bundle 39. In other words, it was for my client to prove that the officer Pringle honestly believed that force was necessary. Secondly, that that belief was objectively reasonable. That's the effect of the Ashley decision. And thirdly, that the force used was no more than objectively reasonable in the circumstances. And we respectfully suggest that the word proportionality to be found in that in two sentences on SB 61 in this context adds nothing to reasonableness. Indeed, for the reasons my Lord Justice William Davis gave, this proportionality and disproportionality are concepts commonly directed to juries. But even if we are wrong on that, even if this court was persuaded to perform a proportionality exercise above and beyond what we might call in the vernacular common law reasonable force, and with respect, the learned judge got it right when she found that there was honest and reasonable belief in the need to use the taser, and what's more, that it was used reasonably and proportionately. It's never been part of my learned friend's case that P.C. Pringle depressed the trigger for more than the usual 5 seconds. Indeed, you don't depress it for 5 seconds, you momentarily press it and you get 5 seconds of the conductive energy.
So do you agree with the judge's paragraph 44 then? Do you, whilst just dealing with the law before you look at the...
My Lord, yes, although of course I have to accept that a decision of the High Court in Northern Ireland does not bind this court, we respectfully suggest that there is nothing remarkable about the learned judge's proposition when he added to reasonable, in other words, necessary and proportionate. Because I hope to persuade this court, not with any erudition that Mr. Clayton treated you to, but with what might be thought to be the common sense of the situation, that when dealing with reasonable force, officers taking decisions in, as the learned trial judge said, in split seconds, the proportionality test being applied is not Lord Sumption in Bank Malat with 4 limbs to it. It is the proportionality test, which is another way of saying that which is reasonable in the circumstances. My lords and my lady, furthermore, it is conspicuous, we say, that the learned trial judge's judgment was not only compellingly detailed and compellingly reasoned, as indeed one might expect from a former practitioner who specialised, amongst other things, in this very area of law, but it was also, if we may say so, very carefully structured. And this court will have noted that having set out the law as agreed between the parties, there was no disagreement on the law at first instance. And she did that between paras 41 and 52, and I don't take this court back to them. She then methodically and painstakingly worked her way through each of the relevant questions, including questions contextually not irrelevant, such as the decision to handcuff the claimant on arrest. My lord, my lady has that from para 54 onwards. And I don't, unless the court invites me to, deal with that, since it is, as it were, might be thought contextual. And then from, more importantly, from 73 onwards, she dealt with the necessarily first question, whether P.C. Pringle honestly believed it was necessary to tase the claimant. So plainly, if his integrity was an issue, then we wouldn't get to questions 2 or 3. And it is noteworthy, we invite this court to conclude as to what she said in paragraph 74. Having recited accurately his contemporaneous use of force form entry for the court's note at SB 35, supplementary bundle page 35, she said, in my judgment, almost all of what P.C. Pringle wrote in this part of the use of force form was objectively accurate. And she then went on to, as it were, make good that proposition: heavy muscular build, heightened emotional state, which the court will note at 76, she said that was an understatement. The claimant shouted the same thing around 25 times and was not listening to what the officers were trying to say to him. This court won't have overlooked, this was now the 5th attempt at getting this gentleman to blow properly. And she continued at 78. P.C. Pringle was justified in describing the claimant as making, quotes, verbal threats. Although the claimant did not explicitly threaten any of the officers with violence, his repeated shouting of, "I'm not going to allow this," was reasonably interpreted as an implicit verbal threat of resistance to arrest. And of course, what one doesn't do is fractionate or compartmentalize these individual points, because police officers don't have the benefit that we have had today of courtroom retrospection in calm circumstances. At 79, she dealt with the removal of the wristwatch. Typical of her nuanced analysis, she accepted both sides' accounts, in effect, that the claimant was simply removing it because the clasp had come loose. But then the important conclusion, however, in the context and atmosphere of this event, I digress to foreshadow what I'm going to come on to when I go to Fage and Calmer, an atmosphere that cannot be recreated in the Court of Appeal. The learned trial judge had 5 days of evidence. It was reasonable for P.C. Pringle to interpret this as the claimant gearing himself up to aggressively resist. 80. The claimant had pushed police hands away, as Pringle recorded in his use of force form. And then she records the attempts of no fewer than 3 officers. I observed contextually P.C. Rickman having been in the city police for less than 6 months. He was a junior probationer. Mr. Hughes sought to portray these as defensive, not aggressive actions. With respect, I disagree, said the judge. The claimant was by this point under arrest, the legality of which he does not challenge. I observe could not have challenged. But the officers were entitled to use reasonable force to effect that arrest by virtue of the statutory provisions. He was not merely pulling away from the officers, he was doing so while very angry and repeatedly shouting. And he had, said the learned judge at 81, repeatedly ignored commands to put his hands out to be cuffed and to calm down. it is, we say, to the credit of the judge and to give this court even greater assurance and confidence that they should not interfere with her careful judgment, that she disagreed with Pringle on one point alone, the fighting stance assessment, and she disagrees over paragraphs 82 to 85. The court has already read that. However, at 86, and this is where the appellate court can never replicate the atmosphere of having seen the officer, his comportment, deportment, the way he answered questions, relative to the footage shown to him by both sides. She said, having heard P.C. Pringle's evidence and seeing this phrase in its full context, I accept that it was an unfortunate shorthand intended to convey his belief that the claimant was readying himself to attack or aggressively resist the officers in the immediate aftermath of throwing off his watch. I make this finding in light of a series of other matters set out at 75 to 81, some of which I just took the court to, which P.C. Pringle had recorded accurately and which were consistent with his belief that these were the claimant's intentions. And that is why at 87 she noted Pringle's recording of his assessment of the claimant as posing a significant physical threat due to his aggressive attitude, stance and general agitation, which is why in his MG11 he wrote, I firmly believed was about to attack or aggressively resist police, fearing that the male was steeling himself to attack officers. I fired the taser. A difficult decision in difficult circumstances. But the court will also note, if I may just for your note give you, that P.C. Pringle had been put on notice as to this fulminating problem much earlier in the episode, which had been going on for more than half an hour. The court will note that from paragraph 16 of the judgment, where Worcester, if I can call him the older police officer in spectacles, has called Pringle, and that's not captured on footage but was accepted by the judge. And Worcester is explaining the failure repetitively to blow properly, and he's just lining up potential assistance, as any experienced and good officer would do.
Is that the exchange that's then we see in the chronology?
No, that's the next one, my lady.
Right, that's the next one.
At paragraph 20. Because at 5:57, which is captured in the chronology, Worcester made another call to Pringle, and the learned trial judge has recorded that in extenso within paragraph 20. And of course, she is having regard to all of the evidence. She's not island hopping the way my learned friend Mr. Hughes very eloquently and skillfully just did. And by the time Pringle moves in, so to speak, that's the third time he's been called. See paragraph 27. This court, of course, will keep in mind that the judge is looking at the evidence of Pringle and his antecedent involvement, which is that he's getting warmed up to attend, but they don't just pile in at the scene. He plots up nearby so as not to aggravate, so as not to create a confrontation. And then at 27, the third call, P.C. Worcester called P.C. Pringle by radio, asking him to make his way to the scene. Claimant said to Mr. Cole, who was standing by the car, they just said that was it, and now they're saying they're going to cuff me. Worcester said, you're under arrest now. He placed his hand on the claimant's arm, he pulled it away and said, mate, I ain't doing it. You told me that was it. So that's the scene to which Pringle arrives, and that is why the learned trial judge concluded, as she did at paragraph 90, that P.C. Pringle honestly believed it was necessary to taser the claimant. Then she moved, as she had to the second test in civil law, not to be found, of course, in criminal law, as to whether that belief was objectively reasonable, and she subjected that question to her customary detail over the paragraphs 91 to 100, and the court will be relieved that I need only focus on 97, 98. Because at 97, she directly asked the question whether the relevant guidance was complied with. The APP guidance makes clear that a taser, quotes, should not be used to simply gain compliance with instructions or procedures where compliance is not linked to such a threat. And she references the sort of threat she has in mind back to her paragraph 17.
And so she uses the guidance as a tool of testing reasonableness.
Exactly, my lady. And then, again reflecting her nuanced approach, she says, in one sense, the taser in this case was used as a compliance tool. The officers at the scene appeared to think that, and then she lists them. PC Pringle said the claimant got tasered for not doing what he was told, and PC Rickman said it was because he refused to comply. However, I consider that is too simplistic an analysis for two reasons. First, the compliance in question was compliance with a lawful request that the claimant be handcuffed, as he was already under arrest that was never challenged as to its legality, such that the statutory powers to use force under sections 3 and 117 had been triggered. Second, the use of compliance remained linked to the threat posed by the claimant, such that it was permissible within the wording of the guidance. This is because PC Pringle's concern that the claimant was not complying with the request to be handcuffed was inextricably linked with what he thought the claimant would do instead, namely aggressively resist or attack the officers, that being the nature of the threat. He explained at trial that his words quoted at the outset of this paragraph were a clumsy way of explaining his rationale, and the claimant's quotes, not letting officers handcuff him, led me to believe there was a threat. And she goes on to amplify that in paragraph 99, and then at 100, and obviously I invite reading by the court of 99, at 100, Mr. Hughes submitted that I should find as a fact that nothing was about to happen that necessitated the use of force. He may be right that nothing would, in fact, have happened had the taser not been discharged. However, what matters is whether PC Pringle's belief in what might happen, so as to justify the use of the taser, was objectively reasonable. I am satisfied that it was, even if Pringle was mistaken in his view that the claimant was going to attack the officers or aggressively resist any further attempt to restrain him. This was a reasonable one on which he is entitled to rely. And then, what the learned judge did was...
Can we, just before we leave that,
of course,
sorry, and going back to the 93, just to test the objective reasonableness, because here she's dealing with Mr. Hughes' submission that he posed no further threat, which is when he's sort of shut his arms. And PC Pringle says, that's a gesture of come and get me. In those circumstances, is it objectively reasonable to taser someone?
My lord, if that was the only thing, I would struggle maybe. But the very reason I pulled my learned friend Mr. Hughes' leg about island hopping is that this case is all about the whole of the sea of the evidence, not just one matter. And if I may say so, it would be very difficult to criticise this judge for not rehearsing the detail of the evidence in considerable detail, because she plainly did, and she had regard to everything, including material, as is often the way with trial judges, that isn't in fact that doesn't find its way into the judgment. She says that in terms at 96, when she refers to my learned junior's reference to the body worn not being all of the evidence, and she accepted that. So that if it was just that one physical act, and there was nothing else, there had been, for example, not 4 previous failures to blow properly, followed by another failure to blow properly. May I remind...
Sorry, what have they got to do with the level of force used following arrest?
Because what they do is they inform the officers as to likely cooperation, as to likely...
he never refused to take a test, did he?
No, what he did was he pretended to take a test, as the learned trial judge found at 171, because when she was dealing, it's core bundle 61, in terms of looking at the attitude of the arrestee that the officers were having to deal with, as part of the unsuccessful attempt to have the claimant characterised as fundamentally dishonest, which I needn't trouble the court with because the defence was unsuccessful, the learned trial judge did deal with the question of why was he repetitively not breathing properly. And she dealt with it at 171, core bundle 61. Claimant did not suggest that any breathing difficulties had prevented him from giving the sample. Rather, his case was, first, that he was cooperating with the breath test procedure, and second, only stopped blowing into the device once PC Worcester said that was it. I cannot accept either of these propositions. I accept the defendant's analysis that the claimant stopped exhaling at the point at which he can be seen raising his eyebrows and blinking before PC Worcester said, that's it, sounds like that's happened. In my judgment, the defendant has proved that the claimant has been dishonest about these issues. I'm simply injecting, by way of balance to my learned friend's island hopping, a little bit of contextual realism. This gentleman declined to provide 5 separate occasions, thereby abstracting more officers to the scene. If I may just quickly revert to where I was, 101 to 106, paradoxically or ironically, I don't know which word is better, might be seen as an example of the judge, consciously or otherwise, applying, as it happens, a proportionality consideration, because she thought about 2 other options that Mr. Hughes had floated by way of alternatives to taser: parva incapacitant spray and exercising patience. And she dealt with both of those matters, and in short, in relation to parva, not of course that I need to rely on this, but simply by way of illustrating the thoroughness and care of this trial judge, she listened to the evidence about cross-contamination and risk of injury to officers, and then as to the option of patients, 105 and 106, she sets out in considerable detail why she considered that the officers couldn't be criticised for lack of patience. Indeed, she concludes at the end of 106, PC Worcester insightfully said, listen, there are too many voices. PC Pringle shouted, put your hands out, do as you are told, one further time, at which the point the claimant folded his arms. In other words, he didn't do what he was lawfully told to do. In my judgment, PC Pringle was objectively justified in concluding at that point, just before he discharged the taser, that further negotiation with the claimant would be futile. And I won't trouble the court by reading through the judge's careful findings of the primary facts on which she based her evaluation, but might I invite the court to reread paragraphs 13 to 34 of her careful findings of fact, because one thing the court will notice is the exceptional number of warnings, not only that the police officers present gave to this gentleman, but that his own very close friend, Mr. Cole, did, because as the learned judge has observed 31 to 33, and she has put the numbers in because they're so striking, on no fewer than 21 occasions, Mr. Cole is warning his mate, don't get tasered, don't get tasered. And you hear that, I'm afraid, on the video, because his friend can see how thoroughly unreasonable and resistive he regrettably was. And so I invite the court to find that so far as the three key questions to be found pithily exposed in paragraph 52 of the learned judge's judgment, she amply explained why she found in the favour of the City of London Police for all three. May I, before the adjournment, I can probably almost conclude, because...
Well, don't feel under any pressure. It was occurring to me, and I haven't discussed this with my lords, but we might restart, given the good progress that's been made, at around 2:45 and spend the first 45 minutes viewing the video footage together in the light of Mr. Hughes' submissions. So don't feel under any pressure if you...
I'm very grateful. I won't feel under pressure, but equally I can take the next points.
Yes, do.
Can I, just before you leave that last point, and at 106, and just ask you this question about the judge's conclusion, which was further negotiation would be futile, accepting that to be right, because the claimant seemed to be obsessed with the words "that's it" and his understanding that he didn't need to blow anymore, and the machine and all the rest of it. But even if it is futile, why does that justify the use of a taser?
It's not the futility of further negotiation, it's the threat that he is going to attack the officers. And that's what the learned trial judge found at 98, where she says, this is because Pringle's concern that the claimant was not complying with the request to be handcuffed was inextricably linked with what he thought the claimant would do instead, namely aggressively resist or attack the officers, that being the nature of the threat. And so the futility of further negotiations is simply part of the contextual matrix.
Thank you. Sorry to interrupt.
Well, you may say that. I mean, it's the judge, as you rightly observe, carefully structured her judgment and dealt with each issue separately. And this is coming on to the final issue. Nothing to do with PC Pringle's belief, whether that was reasonable or not, but was it reasonable, objectively, to use a taser? And in this point, that's the point at which she reaches this view about the objective justification for concluding further negotiation would be futile.
Yes, and I entirely accept the point that's been made. It's a separate point from the objective belief as to the need. It's a separate factor. I would invite the court to regard that as just part of the factual findings. It's not something that points screamingly to not using a taser, since his primary reason, as she found, was the threat he posed to the other officers. Bearing in mind I didn't take the court, in the interest of economy, through her line-by-line assessment of the threat that he did pose, giving rise to the honest belief as to the need to use.
Yes, well, we've obviously all read the judgment very carefully.
Yes, and you're going to look at the video yet again, but if I may say so, you don't really need to, for the simple reason that the trial judge went through it in immaculate detail. And she had the benefit of something the three judges in this court don't have, which is the cross-examination of Pringle and the cross-examination of the claimant. The only two bits of discrete law with which this court will be intimately familiar I was referring to was the Phage Greek yogurt case at Authorities Bundle 125 and the well-known observations of Lord Justice Lewison. Appellate courts have been repeatedly warned by recent cases at the highest level not to interfere with findings of fact by trial judges unless compelled to do so. I'd respectfully suggest there's nothing about this judgment that compels a raised eyebrow or circumspection. This applies not only to findings of primary fact, and those were the findings that started, of course, at paragraph 9, but also to the evaluation of those facts and to inferences to be drawn from them. And then the Lord Justice set out his reasons for this. At 1, the expertise of a trial judge is in determining what facts are relevant to the legal issues to be decided. This court might note that the legal issue now raised is completely different from that raised below. And I can skip at the top of 1, 2, 6, 2 and 3 and simply alight on the memorable phrase, in making his decisions, the trial judge will have regard to the whole of the sea of evidence presented to him, whereas an appellate court will only be island hopping. 5, the atmosphere of the courtroom cannot in any event be recreated by reference to documents, including transcripts, and you of course don't have full transcripts, neither party has suggested you should. Thus, even if it were possible to duplicate the role of a trial judge, it cannot in practice be done. I've cited 115 in my skeleton, I needn't trouble the court with it now. And then just before the lunch break, at page 152 in the same bundle, these comments were more recently echoed by Lord Justice Coulson when he effectively repeated what the Lord Justice Lewison had said and added at the bottom of 152, the Supreme Court has regularly explained that unless a critical finding of fact has no basis in the evidence or is based on a demonstrable misunderstanding of relevant evidence or a failure to consider such evidence, an appellate court will interfere with the findings of fact made by a trial judge only if satisfied that his or her decision cannot reasonably be explained or justified. And the circumspection and respect for the trial judge is emphasised by Lord Justice Coulson. We would respectfully say there is no critical finding of fact absent a basis in evidence. There is no demonstrable misunderstanding of relevant evidence. The obverse is surely true in this judgment. There is no evidence of a failure to consider relevant evidence. And for those reasons, it is not, we say, for this court to supplement or replace the views of the trial judge with their views, disadvantaged as you are by the absence of 5 days of live evidence. My lady, although I think, as a matter of caution, I will formally reserve my position, I think I have substantively probably concluded.
Well, that's very helpful. You've been very efficient and organised and clear, Mr. Beggs. Thank you very, very much indeed. Given the progress we've made, would it be sensible for us to resume at 2:45? For any points you have to make in reply, we will use the 45 minutes well and come back into court, therefore, at 2:45. Yes, just one moment.
Mr. Beggs, can I just ask you to think before 2:45? Should it be that we conclude that this was a decision in relation to questions 2 and 3 that no reasonable judge could have reached, and we therefore allow the appeal, will you be in a position, please, to help us about, well, what's the consequence of that in terms of the remedies that the judge, the decision the judge reached on remedy? Because, of course, she very sensibly went on to say, if I'm wrong, then here's the consequence.
She did.
But for myself, I can't immediately identify whether she was reaching her conclusions based on if I'm wrong about everything or if I'm just wrong about the taser, because it's only the taser with which we're concerned today.
Yes, may I think about that?
Yes, absolutely. That's why I said it now.
Thank you. Thank you.
Court rise and table.